Welcome back to the House. Now, it's well established in Canadian law that a patient has the right to consent or to refuse to consent to any treatment. The right to refuse treatment means that a patient is permitted to make decisions about their own care, even when those decisions are in effect terrible decisions or have terrible outcomes. And this happens a lot for many different reasons, whether personal, religious, financial, emotional. And this is challenging enough for a provider. Less clear is when a patient can withdraw consent. An important caveat here, whenever consent is withdrawn in something that you're involved with, it's really important to pay attention. Here we're talking about the withdrawal of consent for treatment, but if consent is withdrawn in other scenarios, let's say an intimate setting, that means stop. No means no, stop means stop. The withdrawal of consent should result in a withdrawal, if you catch my drift. Full stop, end of story. We've already established that withdrawing consent for treatment is possible. After all, this was at the heart of the Hamilton Health Sciences and DH case. DH withdrew JJ from chemotherapy. That decision and the decision made by Michaela Sue's parents have sparked debates about the withdrawal of care, particularly when it includes children's treatment. Whether or not we should allow some patients to make these decisions is maybe a matter of debate, but it's really well established in law that it is the right of a patient to make decisions for themselves. Section 14 of the Healthcare Consent Act clearly states this, noting that consent that has been given by or on behalf of a person for whom the treatment was proposed may be withdrawn at any time. And it can be withdrawn by the person who made the consent in the first place if they remain capable, or by the person's substitute decision maker if the person is incapable. That a capable person or their substitute decision maker is able to withdraw consent is part of the patient's right to self-determination. In Cerello and Schrader, the Supreme Court of Canada explicitly recognizes, noting that an individual has a right to withdraw consent unless stopping it would endanger the patient's life or threaten some sort of immediate or serious health problem. I.e., you might not be able to withdraw consent mid-surgery, or at a minimum, the surgeon might have to put all the pieces back together. The court also noted that patients have the right to be free of procedures to which consent has not been given, which includes the right to stop the procedure. The court noted generally if there is any question as to whether the patient is attempting to withdraw consent, it will be incumbent upon the doctor to ascertain whether the consent has in fact been withdrawn. If consent is withdrawn, it has to be reobtained before proceeding, and here, the newly obtained consent, in order to be informed, must include any material changes in risk, dangers, etc. Now, it's up to the provider to determine if consent has been withdrawn, and if the courts are included, they're going to look at the words as well as the surrounding circumstances issues. Consider the two following cases. In Nightingale and Kaplovich, a physician is performing a sigmoidoscopic examination of a bowel. I don't know if I said that right, but it's an examination of a bowel with a scope. When a patient screamed out in pain, "Please stop, I can't take this anymore." The doctor replied that he was almost finished and it was looking pretty good and continued with the scope. A few minutes later, the patient experienced severe pain in their shoulder and chest, which just so happens to be an indication that their bowel had been perforated. Just an FYI, it can also mean other things, but in this instance, the bowel was perforated. In Mitchell and McDonald, while receiving a cortisone injection in the back, the patient cried out, "For God's sake, stop." Now, which of these is a withdrawal of consent in your mind? Both? Neither? One of them? Just to make it confusing, the court isn't always clear. In Nightingale, the court held that there was a withdrawal of consent with "please stop, I can't take this anymore," and that the continuation of the procedure after the patient had withdrawn consent constituted a battery as well as negligence. Recall that here battery is the tort for physical contact without consent. Negligence we'll talk about later in the term. In the second case, Mitchell, the court held that "for God's sake, stop" was not a sufficiently clear withdrawal of consent. It reasoned that the patient could have meant stop the pain rather than stop the injection, because that makes total sense, right? Now, I've had both types of procedures, or at least similar, although admittedly I was under anesthetic for my scope, but I suspect that the injection was seen by the court as simply a less serious procedure overall. And just a quick needle in the back, quick and done. Mind you, of the two procedures that I had, that's the one that really made me the most nervous. But how is "for God's sake, stop" not clear? How is it different from "please stop"? Had the patient in Nightingale said, "For God's sake, stop, I can't take it anymore," would that have been a withdrawal of consent? Or would they have been barred from their claim? Was it the fact that they said "please"? Like, "for God's sake, stop" and "please stop" are both stops, no? And while a doctor in both situations should have stopped to ascertain the wishes of the patient, the court's differentiation here for me is problematic. How are providers supposed to ascertain the meaning if "stop" can be interpreted different ways? Shouldn't "stop" be sufficient in both cases? Stop means stop, no means no. Now, this is what happens when the patient is capable and can actually express their views. Imagine the challenges now that arise when a patient is incapable, like JJ or Michaela, or a lot of other patients that might not be able to speak up for themselves, who might not understand what's actually going on in a procedure. Consider, for example, Mr. Jansen from last week's video. Both his wife and his sister had different views of what should happen regarding his treatment. The court ultimately decided to award his wife the role of his substitute decision maker because it aligned with his views, and that resulted in his life support being removed, being withdrawn. But what happens if a patient who perhaps has dementia and their caregiver has consented to a treatment, and during that treatment they're saying "stop" because they don't quite understand what's happening? Perhaps they're afraid, or they're uncertain, or it's scary. How do we know when consent has actually been withdrawn? Now, what the doctors think is best and leads to the least amount of suffering also has an impact on what we allow. Consider the example given by Daniel in his guest lecture, a Charlie grad who wasn't allowed to go home to die with his family because of the court's views and the doctor's views on how this might increase his suffering. So doctors can clearly help decide when a patient's life should come to an end, right? Well, this brings us to the landmark case in substitute decision-making and end-of-life care in Canada. That's the focus of this week's Too Long Didn't Read. This week's case is Cuthbertson and Rizzulli. It's a 2013 decision from the Supreme Court of Canada. It involves a patient, Mr. Rizzulli, who's in a persistent vegetative state and on a respirator at the Sunnybrook Health Centre in Toronto. His physicians wanted to take him off of the respirator and offer him palliative care because they felt there was no prospect of him regaining consciousness. And while life support was prolonging Mr. Rizzulli's life, they believed it was intrusive, possibly harmful, and of no medical benefit. Mr. Rizzulli's wife, Ms. Salasso, who was his substitute decision maker, refused to agree based on Mr. Rizzulli's religious beliefs and her view that he was not in a persistent vegetative state. So she sought an injunction to prevent the withdrawal of life support without her consent. The physicians argued that they did not need her consent, as the withdrawal of life support did not constitute a treatment. The trial judge granted the injunction and the hospital appealed. Now, at the Court of Appeal, the court stated that physicians do not generally require consent to withhold unnecessary or futile treatment, noting that patients cannot demand whatever treatment they wish. Now, just for a moment, let's talk about futile treatment. What does it mean? Simply stated, medical futility refers to a physician's prognosis that as a consequence of some illness or injury, further therapy will not improve the patient's condition and therefore shouldn't be attempted. Burnett notes that the term has been used when a treatment will produce either no physiological effect or when a therapy might produce a physiological effect, but that effect will provide no medical benefit to the patient. So it could have an impact, but not enough to warrant continuing. But what is the benchmark for this kind of decision? Burnett further notes that one review showed that some physicians do not declare a therapy futile unless the success rate is 0%, while others might consider it futile even with a success rate as high as 13%. Moreover, Burnett points to studies that show that the concordance of futility determinations by physicians and nurses in an ICU identified disagreement regarding at least one daily futility judgment in 63% of dying patients. We don't agree on what is futile, not just in society, but in medicine. As one commentary notes, the use of futility seems to hide the inherent moral content of medical decision making. And as a consequence, there have been many calls that futility should be abandoned. It's not required in cases of physiological impossibility where nothing will ever improve. And in all other areas, it's a question of value judgment. Returning to Razzouli, the Court of Appeal held that withdrawing life support and immediately providing palliative care constituted a treatment package under the Healthcare Consent Act, and that required the patient's consent or that of his or her substitute decision maker. If the hospital believed that Mr. Razzouli's wife was refusing consent in violation of Section 21(1) of the Healthcare Consent Act, it could always apply to the Consent and Capacity Board to overturn her refusal. The court actually acknowledged here that the current law was not ideal. For example, if a substitute decision maker is acting on the patient's prior expressed capable wishes, there would be no violation whatsoever of Section 21(1). In this event, the Consent and Capacity Board's hands would be tied, and the physicians would be required to continue life support despite their view that doing so was contrary to Razzouli's best interest. The hospital then appealed this decision to the Supreme Court of Canada. The majority of the Supreme Court of Canada also broadly interpreted the word treatment, and they upheld the Court of Appeal's decision that consent was required to withdraw life support. The majority stated that the Healthcare Consent Act was a carefully tailored statute that appropriately balanced the parties' competing interests, and it didn't accept the physicians' arguments that they would be put into some sort of untenable ethical position if they had to continue the futile care that they believed was contrary to Mr. Razzouli's best interests. Before we dive further into the judgment, it's worth noting that there was a dissent here of two justices who forcefully argued that the common law, and not the Healthcare Consent Act, governed disputes about withholding and withdrawing life support. They noted that the Healthcare Consent Act was never designed to resolve issues related to medical futile treatment, and that the definition in the Act of treatment did not include withholding or withdrawing treatment, and that the withdrawal of treatment and the provision of palliative care were actually separate acts. And as neither the Healthcare Consent Act nor the common law requires a patient's consent to withhold or withdraw treatment, the extension of patient autonomy in this way would essentially permit a patient to insist on receiving futile care to the detriment of the physician's legal, ethical, and professional duties. The dissenting judges concluded that the continuation of life was not an absolute value and that physicians should not be required to breach the accepted standards of care and the ethical principles of their profession. Now, remember that the Healthcare Consent Act exists to do, among other things, enhance patient autonomy around treatment decisions. So this is really about whether withdrawal of care is a treatment. And the Healthcare Consent Act, in addition, allows those who have been found incapable to apply to a tribunal to review this finding, allows incapacitated individuals to request that the tribunal appoint a representative of their choice to make a decision on their behalf concerning treatment, and can actually promote the communication between physicians and patients to help ensure there's a supportive role for family members and persons who lack the capacity to decide on a treatment. And similarly, physicians can apply to the Consent and Capacity Board if they feel that a person either lacks capacity or their substitute decision maker is not acting according to the Healthcare Consent Act. So there are safety mechanisms in place here. The court here is really wrestling with two major questions. The first is, what is the role of physicians in having the final say on when to stop life-sustaining treatment when it's no longer perceived to be beneficial to the patient? And the second is the role of families and substitute decision makers acting on behalf of the incapacitated patient to be able to defend their wishes for further medical intervention and be able to demand continued care. Here, the physicians that were responsible for Mr. Razzouli's care believed that he was in a persistent vegetative state. They deemed all appropriate treatments for his condition had been exhausted and that there was really no realistic hope for his medical recovery. With this information, they believed that continuing the life support would not provide any medical benefit to the patient and may actually cause him harm, and thus they sought to remove his life support and to provide palliative care until his expected death. The court notes at paragraph 34 that the physicians argue that treatment under the Healthcare Consent Act is limited to what the attending physician or caregiver deems to be of medical benefit to the patient. In other words, what is medically indicated. Mr. Rizzuli's physicians have concluded that life support no longer offers a medical benefit despite keeping him alive, given his unconscious state and the extreme unlikelihood of his recovery. It follows, they argue, that the provision of life support for Mr. Rizzulli has ceased to be a treatment under the Health Care Consent Act, obviating the need for consent to its withdrawal. Here, the physicians are arguing that the definition of treatment under the Health Care Consent Act is limited to what attending physicians or caregivers deem to be of medical benefit to the patient. And because life support no longer offered this benefit, despite keeping him alive, that there was no need to continue and it wasn't a treatment. In short, the physicians argued that the withdrawal of life support was not a treatment under the Health Care Consent Act, and therefore that the Health Care Consent Act no longer required them to actually obtain consent for this, because it wasn't a treatment. And Ms. Salasso there, Mr. Rizzulli's wife, was really not a relevant factor. Now, the majority of the court here noted at paragraph 38 that the issue is not the correctness of the physician's professional opinion that sustaining life in Mr. Rizzulli's situation confers no medical benefit. In fact, their opinion, the court notes, appears to reflect a widely accepted view in the medical community. The issue at this stage of the argument is whether maintaining Mr. Rizzulli's life serves a health-related purpose within the meaning of the Health Care Consent Act. And the court concluded the words of the Health Care Consent Act on their face cover provision of life support that is effective in keeping the patient alive and forestalling death. Life support arguably falls within the therapeutic and preventative purposes listed in the definition of treatment in section 2.1. It's therapeutic here because it's maintaining life, which has a good effect on the body and in the sense that it's keeping it alive, and is preventative in that if death is considered harmful or the manifestation of ill health, then life support serves a preventative purpose as long as it's effective in preventing death. The inclusion, therefore, of life support in treatment is generally supported by the objects of the Health Care Consent Act, and it provides consistency with respect to consent. It protects autonomy through the requirement of consent and provides a meaningful role in the consent process for family members and substitute decision makers. At paragraph 68, the majority concludes, in summary, withdrawal of life support aims at the health-related purpose of preventing suffering and indignity at the end of life, often entails physical interference with the patient's body, and is closely associated with the provision of palliative care. Withdrawal of life support is inextricably bound up with care that serves health-related purposes and is tied to the objects of the Act. By removing medical services that are keeping a patient alive, the withdrawal of life support impacts patient autonomy in the most fundamental way. The physician's attempt to exclude withdrawal of life support from the definition of treatment under Section 2.1 of the Health Care Consent Act cannot succeed. Now, the physicians also argued that requiring consent for the withdrawal of life support would place them in an untenable and unjustifiable ethical position. And as for that argument, the court notes that these tensions are kind of inherent to medical practice. And while the end-of-life care may pose some particularly difficult ethical dilemmas for physicians, it does not alter the court's conclusion that the withdrawal of life support constitutes treatment and therefore requires consent. The court noted, wherever one tries to draw this line, it is inevitable that physicians will face ethical conflicts regarding the withdrawal of life support. No legal principle can avoid every ethical dilemma. What might be needed is a practical solution that enables physicians to comply with the law and to satisfy their professional and personal ethics. And the court considered some of the options that were available to the physicians here, including the possibility of transferring Mr. Rizzulli to a different hospital, alternate staffing arrangements within the present hospital, or involving other physicians qualified to undertake Mr. Rizzulli's care who might not have the same ethical objection with continuing the administration of life support. And the court noted that such practical solutions could go far in averting any ethical conflict, and so didn't buy into this claim by the physicians. Let's turn to the second question now, which considers whether the families of incapacitated patients should be able to defend their wishes for further medical intervention and demand continued care. Mr. Rizzulli's wife and substitute decision maker, Ms. Salasso, had argued to keep Mr. Rizzulli alive on life support for a couple of reasons. For one, she didn't accept that Mr. Razzouli was in a permanent and irreversible unconsciousness. She contended that there was new evidence of his neurological function that indicated an increased level of consciousness. Now, this argument is not new. Remember that in Jansen, the sister of Mr. Jansen thought that more time may prove beneficial. Indeed, this is often the case in situations with people in vegetative states, and there are some confounding reasons and cases why we might be reluctant or people might be reluctant. Consider the locked-in syndrome cases that make people have hope that their family member may actually be such a person. Ms. Salauso also didn't think that the life support withdrawal aligned with Mr. Razzouli's views as a Shia Muslim. She held that his religious beliefs would mean that he would want to be kept alive. On this point, it's important to note that it might not actually matter if Mr. Razzouli's beliefs were in fact consistent with the Shia perspective. Religious freedom is protected, and the importance of religious freedom is often noted, and the courts have also identified that religious beliefs do not need to align with orthodox doctrine. And this can be sometimes confusing because there may be religious beliefs that are not actually justifiable within that religion. Like, there's one paper that looked at the Shiite views at the end of life and noted that there is no clear directive on things like do not resuscitate orders in Islamic sources, and that some of these issues have not been fully resolved, and that sources have pointed out that physicians are permitted to stop offering futile treatment, and that participants often in studies looking at this establish that in complicated cases, especially with terminal patients, that it should be up to a team of experts who make the decision about whether to continue or stop life-prolonging treatment by examining the situation thoroughly and respecting the patients and their families' requests. The point here is that the religious beliefs of Mr. Razzouli do not have to align with orthodox doctrine to be followed. They're his views. They're his beliefs. Now, when considering the role of the SDM, the court did note that the substitute decision maker does not have a carte blanche right to give or refuse consent. They must still comply with the requirements of Section 21 of the Healthcare Consent Act, which contemplates two types of situations: prior expressed wishes and best interests. Now, if the substitute decision maker is not aware of an expressed prior wish of the patient, or if that wish is not applicable to the circumstances, then the substitute decision maker must make the consent decision based on the best interest of the patient in alignment with the criteria set out in Section 21(2). Thus, Mr. Razzouli's wife would need to take into account what was in his best interest, and that includes the considerations of his values and beliefs that he held while capable. So his views as a Shiite Muslim were relevant for his best interest. It also includes any wishes that were expressed by an incapable person with respect to the treatment. But here he has not expressed anything, and in fact the court said there were no expressed views about the withdrawal of life support, requiring then the next step, which is to consider whether the treatment is likely to improve the incapable person's condition or well-being, prevent it from deteriorating, or reduce the rate or extension of the deterioration. Now, Ms. Salauso was acting to uphold what she believed were the values and beliefs expressed by Mr. Razzouli as a Shia Muslim. Whether she took into account the likelihood of the treatment to improve his condition is a far more difficult thing to assess. Here the court notes the physicians argue that artificially prolonging Mr. Razzouli's life will lead to health complications such as bed sores, respiratory infections, and organ failures, a scenario that could be avoided if life support is removed. Where on the other hand, Ms. Salauso argues that new evidence and evaluations suggest that Mr. Razzouli's condition may improve in the future, mitigating against the removal of life support. She believed that he had increased levels of consciousness, by which logic, life-sustaining treatment would indeed improve his condition. It would allow him to recover. Ultimately, the majority of the court concluded that the appellant physicians, having determined in their view Mr. Razzouli should be removed from life support, were obliged to seek Ms. Salauso's consent to the withdrawal. Since Mr. Razzouli had not expressed a wish within the meaning of Section 21(1), Ms. Salauso was required to determine whether removal of life support was in Mr. Razzouli's best interest, having regard to the factors set out in Section 21(2) of the Act. When the application was brought, it's for the board, the Consent and Capacity Board, to determine whether Ms. Salauso's refusal to provide consent to the withdrawal of life support was in Mr. Razzouli's best interest within the meaning of Section 21(2). If the board was of the opinion that it was not, it could substitute its decision for that of Ms. Salasso, and that would be the clear way of removing life support from Mr. Rizzulli. Here, the court placed considerable weight on the role of the Consent and Capacity Board, recognizing that the board was well positioned to make a determination on whether treatments were in the best interest of the patient, and in light of the statutory objective enhancing patient autonomy and ensuring appropriate medical care. Now, as I mentioned, there was a dissent in this case, and while we're not going to focus on it much, the assenting opinion did note that the word treatment in the Act here is associated with something that is proposed by a health practitioner and done for a health-related purpose. And although withdrawal of life support is something that is proposed by a health practitioner, it is not done for a health-related purpose. Rather, it's done for the purpose of discontinuing treatment. Stated differently, withdrawing life support brings that treatment to an end. So the definitive treatment does not say that it includes discontinuing of treatment. The dissent writes in its conclusion that the Healthcare Consent Act was not intended to cover the withdrawal of treatment. The Act is not intended to provide a comprehensive scheme. Indeed, it specifically provides that it does not affect the law related to giving or refusing consent to anything not within the definition of treatment. And a plan of treatment is described as something proposed or developed by the healthcare team for health-related purposes. The Act does not refer to the withdrawal of treatment except as a specific component of a larger plan for the provision of treatments or courses of treatment. The Act is designed to give effect to the principle of patient autonomy, a principle with deep roots in our common law that permits a patient to refuse medical care, no matter the consequences. However, neither the Healthcare Consent Act nor the common law permits a patient to dictate treatments. There is no common law consensus that a doctor requires the consent of a patient to withhold or withdraw treatment. Here, the court also noted that a patient's wishes, ideals, and values are important considerations in end-of-life decisions in an institutional setting. However, the continuation of life is not an absolute value. The ultimate decision whether to withdraw life-sustaining treatment must respect the medical or physical consequences of withdrawal or continuation of life support, and also the personal autonomy, bodily integrity, and human dignity of the patient. A doctor cannot be required to act outside of his standard of care and contrary to his professional duties. Now, this case has had important implications in the healthcare field and has ongoing implications for what it means to withdraw life support, which has now been deemed to be a treatment decision. So consider here, for example, the case of WR. WR was an 89-year-old woman with advanced dementia. She was nonverbal and bedbound, and before her admission to St. Michael's Hospital in Toronto, she was in a long-term care facility. She had 2 daughters, one of whom, LR, was her substitute decision maker by power of attorney for personal care. In April of 2024, WR required intubation and mechanical ventilation to remain alive. After several weeks, the treatment team presented LR with a proposal to remove life-sustaining measures while providing comfort with the expectation that WR would pass away within days or weeks. LR did not consent to this and instead asked for a tracheotomy to be performed to prolong WR's life. Believing that LR's decision was not in WR's best interest, a physician on the team made an application to the Consent and Capacity Board to determine whether or not LR was complying with the principles of giving or refusing consent set out in the Healthcare Consent Act. The board here rendered a decision directing LR to consent to the proposed plan of treatment. Cuthbertson and Rizzulli was applied here, and it was used to demonstrate that the Healthcare Consent Act calls for substitute decision makers to make decisions on behalf of an incapable person that are based on objectively interpreted best interest. Specifically, paragraph 88 from the Supreme Court of Canada decision was cited, which notes, the substitute decision maker is not at liberty to ignore any of the factors within the best interest analysis or substitute her own view as to what is in the best interest of the patient. She must take an objective view of the matter, having regard to all the factors set out, and decide accordingly. This is clear from the mandatory wording of the opening portion of section 21.2. The decision makers shall take into consideration. When making decisions on behalf of someone else, and you have to consider the best interest, there's an objective inquiry that's required. The court in WR didn't question LR's love for her mother, just like DH's love for JJ wasn't questioned. But the reality is that the best interests requires an objective decision. The intent of the statute is to obtain a decision that, viewed objectively, is in the best interests of the incapable person. Now, in Cuthbertson and Rizzulli, ultimately, Ms. Salasso won the case, and Mr. Rizzulli's life support to be withdrawn would require her consent. And in December of 2013, it was reported that Mr. Rizzulli was actually going to be moved from Sunnybrook to Toronto's West Park Healthcare Centre. Now, this would mean that Mr. Rizzulli would no longer be under the care of the doctors who wanted to remove him from life support, but ultimately the family said they'd have to pay about $1,700 a month to accommodate that, and they couldn't afford to do it. So Mr. Rizzulli at that time remained at Sunnybrook Health Centre. Now, this was prepared with some assistance from my practicum student, Emily, and we did some digging. We really don't know what the current state of Mr. Rizzulli is, and it might not really be our business. The point here is that Mr. Rizzulli's decision to withdraw life support was not something he could make because he was incapacitated, and so therefore his substitute decision maker was granted the opportunity to make that decision on his behalf, provided that that was made in his best interest. Arguably, in 2025, it may no longer be in Mr. Rizzulli's best interest to be on life support. However, the current status of Mr. Rizzulli is unknown and really none of our business. This is really a case where there's no wins. Like, let's consider if the physicians have won and the legal precedent that would have been set that doctors have the sole right to make decisions about when to withdraw life support from a patient without getting and obtaining consent from a substitute decision maker. On the other hand, here where the family and the substitute decision maker wins, we've now demonstrated that there's an ability to use up valuable hospital resources in a way that prolongs a patient's life, but maybe also their suffering. And that may take away resources from other patients that require them. This is a case that demonstrates how courts do intervene in matters of care because they are a public concern, but also that those have consequences and that we need to grapple with those consequences. And this is what occurred at Sunnybrook itself following the decision by the court. Perhaps it's time for us in society to have a little bit more of a nuanced discussion about the end of life, particularly as we start to develop and create more and more technologies that allow us to sustain life. I think if we were to find out that Mr. Rizzulli remained on life support right now, that we'd probably all be a little concerned that that wasn't in his best interest. Like 12 years of life support is not hope of recovery anymore. So at some point we have to have those discussions. And of course, a physician could have applied to the Consent and Capacity Board to have Mr. Rizzulli's best interest considered and Ms. Salasso forced to consent with the withdrawal of life support. But that puts a lot of onus on physicians and puts physicians and patients in a bit of a conflict that is already problematic. Like, the court didn't think it was an ethically untenable position, but that's what the physicians felt and believed. And of course, there are many other challenges that arise here. We could have conflicting positions with family members, like in Jansen, or many other cases. The reality is we have to have better conversations about the end of life, which is why I'm encouraging you to have those conversations with your family and your loved ones so that it's not guesswork. At the end of the day, this was all conjecture on behalf of Mr. Rizzulli. And of course, his wife, Ms. Salasso, probably had a lot of insight into that, but maybe not. We don't always share what our views and preferences are, and so it was still our best guess, perhaps. Now, this is why we should have documentation or advanced directives or other mechanisms in place that can help make that decision. But I think there's also a bigger conversation that needs to occur in society about what are we willing to do to keep people alive, and what is the obligation of the healthcare system to sustain that? Ms. Salasso mentioned that she couldn't afford the healthcare facility in the other side of Toronto, but does that impose a burden on the healthcare system to cover that costs? And haven't we just seen decisions from our court saying that our healthcare system is under such kind of pressure that we can impose costs on individuals because of that? The reality is some of these situations are tragic. It's sad that Mr. Rizzulli was in a persistent vegetative state, and it's sad to think that his family was fighting to give him the hope and the opportunity of recovery. But it's also really important that we don't lose sight of the broader implication here of what it means to act in the best interest of a patient. Whether that be a child like JJ or Mr. Jansen or Mr. Rizzulli. The court says it has to be objective. But can we be objective about what's in someone's best interest when we're considering their views and preferences or when we're their family members? These are things that I think, despite the fact that the Supreme Court said the Healthcare Consent Act was a carefully tailored statute, that really aren't addressed and that we need to have better conversations about in society. So at a minimum, I hope that you are inspired by the tragedy of some of these stories to at least have that conversation with your loved ones and perhaps identify or think for yourself what it is that you would want, because it's going to be important potentially someday. And when it is important, we really want to make sure that we honor autonomy and not simply impose the views that others may have, whether they're physicians or family members. My glasses are dirty. My glasses are dirty. I'm just gonna clean my glasses for a minute. Hopefully the camera lens is not dirty. I'm not gonna even keep this B-roll, but whatever. What ifs, Jake? What ifs?